it's not, he wasn't trying to deny his ID. They just, he didn't understand what my client was saying. But the simple fact is, if you put someone in handcuffs, under my case law, what a reasonable man would think, you got me under handcuffs if you're hanging in front of your police car and you yet to tell me anything and you wait for another officer, I'm gonna assume that I'm under arrest. And at that point, his Miranda rights should be kicked in so he can decide if he's gonna answer questions or not. At least he knows his legal rights. As far as him only being asked once, well, you don't have to be asked twice. If you're scared, you'll answer right off the bat. But under the reasonable person point, if I was in handcuffs in the back, I'm thinking I'm going to get arrested. So at that point, second officer shows up, that rookie officer should have went and told the guy, hey, this is what he's being stopped for, let him know, read him his Miranda rights. Instead, he just went straight, he started having a conversation like they're friends. Like, you're not my friend if you have me in handcuffs.
Mhm. But doesn't the conversation, as you said, as though they're friends, doesn't that speak to voluntariness, that it wasn't
No,
a that it wasn't an intense situation, at least from the officer's standpoint, and from your client's standpoint, it wasn't a contentious interaction?
I mean, from the officer standpoint, he's talking to you as a friend, but as far as the one in handcuffs, hey, you're afraid, you're going to, for all you know, you're being arrested. You don't know what you're being arrested for because no one has told you up to this point.
So are you saying that if there were no handcuffs on him and he consented to a search of the vehicle, then it would be legal?
Absolutely, Anna, because you feel more comfortable if you're in handcuffs. But you're handcuffed with your hands behind your back with the lights on and the second officer shows up. I mean, any reasonable person would think he's gonna get arrested.
But with it, and let's talk a little bit about the language barrier. So the officer who communicated to him about the consent to search, that officer was a Spanish-speaking officer, and that officer spoke to him in Spanish?
Yes, Your Honor.
And that officer explained to him the consent to search form in Spanish?
No.
Right, what do you mean, no?
He just asked him, can we search your car? And he said, yes.
All right, so he understood that it was a consent to search form and he agreed to the search in Spanish.
He didn't sign no consent. It was all verbal, Spanish translation. But like I said, if you're under arrest, you don't know your rights, you're nervous, you're handcuffed, you're gonna cooperate with the officer under duress.
All right. This is what the court is going to decide. The court, based upon the evidence that was presented to the court, and the court has considered arguments of both sides, the court is going to deny the motion to suppress. Now, with regards to the evidence that was presented, counsel, you want to make closing arguments?
Just let me get my
Yes.
points. Whenever you're ready, Your Honor.
Yes, I'm ready.
Your Honor, the issue before the court at this point has the state proving the case beyond a reasonable doubt. I submit they have not.
Oh, if you'll slow down a little bit, because she's translating it then.
Regarding to the facts of the case, the officer saw my car traveling in a high crime area late at night. No, did not witness any traffic violation, just ran the plates and found that there was a expired sticker, so he initiated the stop. As the officer followed my client, he states he saw my client reaching into the glove department. The officer states that my client passed up several parking areas, public parking areas, well, they where he could have parked. But instead he pulled over on the side of the street. But at no time did he try to evade He was driving slow enough for the officer to keep pace with him. Now, when the officer stated that he saw my client reaching into the glove department while he was driving, like the back windows were tinted, and it was his opinion that the light on his car showed shadows where he was extending into his glove department. But the video speaks for itself, John. When you look at the video, you can't see any shadows, people extending back and forth.
Mhm.
As a result of that, he believed he was in danger based on his less than 2 years experience as an officer, and approached the driver's side of my client and pulled him out and handcuffed him. But as he watched the video up to that point, my client had his hands on the wheels and was cooperative with the person. Remember, there was a language barrier. As a result of the language, as a result that he saw him reach into the alleged blood department, he pulled my client out, put him in handcuffs, took him to the front of his police car, and at which time he radioed for a second officer who spoke Spanish to come and help him. When the second officer arrived, no time did him or my client, and no time did this officer or the other officer tell him why he was being stopped and what he was being charged with. The officer just started to ask him questions. At this point, he asked my client if he, because during that conversation, my client told him that it wasn't his car, it was his boss's car, that he was borrowing it. When asked to search the vehicle, my client consented. This is still prior to any Miranda rights. During the search, the officer searched the front, the middle console, and underneath some stuff he saw some paraphernalia of volume to use to smoke. And based on his experience, he thought it was a drug paraphernalia. So based on that, he continued the search. He searched the front seat, he searched the glove compartment, he searched the back seat, nothing. It wasn't until we reached up top where the glasses are and he found some stuff. If it's testimony, we have this testimony to be truthful. We hold it officer's testimony to be truthful, then the only movement that he saw my client do during the drive was reach for the glove department, never did he reach for where the glasses should be. Well, all officers told him that he was stated that he didn't, I think he was not under influence of any drugs or alcohol at the time. And the second officer spoke Spanish, which time when they found the drugs, should have read him his rights. Instead, they called in the third officer to read him his rights. Most people that borrow someone's car, they don't do an inventory check of the vehicle before they drive it, so they don't know what's in the car. Unfortunately, things like this happen. Based on the circumstances, Your Honor, I mean, if he's borrowing this car and the officer's only testimony and saw him reaching the glove department and never looked up there, and then my client would have had drugs, we would probably told him he had drugs because he told him he can search the car. He was being honest with the guy. He wasn't aware of these drugs. Based on the circumstances, perhaps it can be my client's drugs, but that's not good enough to find him guilty. You can suspect it is my client's drugs because he is the only one in the car, but that's not good enough to find him guilty on it. My client is possibly guilty of possession of drugs, but that's not good enough to find him guilty on it. My client is probably guilty of possession of drugs, Your Honor, but that's still not good enough to find him guilty, Your Honor. My client is likely guilty of possession of drugs, Your Honor. That still doesn't reach the burden that the state has to prove that he's guilty. My client is highly likely guilty of possession of drugs, Your Honor. That still doesn't meet the standard for the state to meet to find my client guilty. And based on the testimony of the officer that we heard, Your Honor, the state has failed to prove guilt beyond a reasonable doubt, and that's that you find Carlos not guilty.
All right, state.
Your Honor, we have proved the elements of the indictment beyond a reasonable doubt. Beginning with the honor about January 2nd of 2025, Officer Johnston did testify that he was on patrol in a uniform in a marked patrol vehicle on that date when he observed the motor vehicle that the defendant Carlos Vasquez Saldana was operating on a public roadway. Officer Johnston testified that he did run the license plate belonging to the vehicle and the registration came back as expired. And that is the reason for the traffic stop that he initiated. When he initiates his red and blue overhead lights, I think it is of significance that the defendant did not immediately pull over. And the state's exhibit, you can see that the defendant passes up two well-lit areas that were parking lots that he could have pulled into. And while it does not rise to the level of another offense, I think that lends to the officer's credibility of the furtive movements that he observed the defendant making during that time, and also to a consciousness of guilt. Now moving on, when Officer Johnston does initiate contact with the defendant, he does observe him in the driver's seat. There's nobody else in the vehicle. It did come out during testimony that the registered owner is not the defendant. However, he was in exclusive possession of the vehicle. I think that important facts that link the defendant to the car is you see in the state's exhibit that he's wearing a red hoodie that has a construction company. When the officer does search his person, he finds nails in the pocket. There's multiple tools in the car, linking the defendant to the car. Officer Garza does make the scene, and he is the second officer on scene. He's a Spanish-speaking officer that obtains the verbal consent to search. At that time, Officer Johnston goes to the car. He finds a pipe that is consistent with smoking narcotics. At that point, he takes it over, shows Officer Garza, and then he goes back and continues to search the car. When he's searching the car, the methamphetamine does fall down from the sunglasses case that is seized, sent off to the lab. And the forensic scientist did testify that it was 0.253 grams of methamphetamine. Now regarding the affirmative link, or what affirmatively links the possession of the narcotics of the methamphetamine to the defendant, is that broken piece of the pipe that Officer Garza testified that he seized from the defendant's pocket. And so that goes to the intentionally and knowing of the indictment. And so we have proved this case beyond a reasonable doubt, and we ask that you find the defendant guilty.
All right. The court will find the defendant guilty. If you could pull a trial court certification of defendant's rights to appeal, please. And then we'll move into sentencing.
Okay. But I don't have the cause number on it.
All right, I'll put the cause number down.
Appreciate it, thank you.
All right, the court having found the defendant guilty, state, what are you requesting for punishment?
Judge, the defendant does not have any criminal history or any prior felony convictions, and so I think under 42A.551, he is mandatory community supervision, so we're just asking for 2 years probated for 2 years.
We're asking for 1 year probation, Your Honor.
The minimum is 2. So-
Yeah, we're in agreement there.
All right, sure. So the court will sentence you to 2 years in the state jail facility, suspended and then probated for 2 years. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days, no employment as a home health care provider or with minors, bill visits 1 time per month for 3 months, a TAP evaluation in custody, follow recommendations. And your client is not a citizen, correct?
Oh, yeah.
And there's to be no illegal reentry into the United States. Probation, is there anything else? All right, Mr. Saldana, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes,
All right. And counsel, were you ever able to explain this document to your client in in Spanish?
Yes, I use the translator, so there's no mistake, Your Honor.
Great, thank you. All right, you do have a limited right to appeal. Well, not a limited right to appeal. You have a right to appeal because this was a bench trial. And also you have a right to appeal the court's rulings, any of the court's rulings. Do you understand?
yes,
All right, because this is a conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
okay.
All right, good luck to you. Thank you.
May I get excused, sir?
Yes.
Thank you.
Yes.
Thank you. Delegado.
Thank you.
Thank you, Ana. Take care.
Who's here on Amanda Hernandez? Amanda Marie Hernandez. Oh. Oh, okay, thank you. Clinton Dixon.
He went outside.
All right, just have a seat. Roman Flores. Who's here on Roman Flores? Okay, thank you. Gilbert Salinas.
Yes, Your Honor. May I approach?
All right, where's the client?
Peace.
Come forward.
Oh, good.
All right, let me see. All right, so Mr. Salinas, today is your plea deadline date. So are you requesting a jury trial?
No, Your Honor. What I'm requesting is a 2-week, no more than 3-week reset for the plea deadline because we're trying to get with the apartment complex to find restitution amounts, if any, so they can properly evaluate the offer that the DA has made.
All right, Norma. Recall this for the week of July 7th. There will be no further extensions.
I understand, Judge, and I greatly appreciate that.
All right. All right, July 8th. And you'll need to be here in person.
Yes, Judge.
All right, once you sign the reset form, you excuse.
Thank you.
Thank you.
Yeah, no, you want, take care of that first. So take care of it first.
Judge, may I approach?
Just give me a moment. I have to put this in the system.
I wasn't going to.
Um, Clinton Dixon. Hi.
Judge, I apologize for not being here when you called me. I had to go get a tape measure.
Oh,
He's gonna need you close.
oh, most definitely. So you all are going to trial?
Not yet, Judge. You asked me to come back in today,
You're
but
gonna get that information, but this is going to be trial?
I'm hoping not, but
Okay.
I've got to get Dr. Murphy's from court first. I talked to her this morning. The package that she needed from Mr. Dixon is en route to her.
Okay,
So she's thinking 3 weeks.
all right.
Now, if she's got to do an in-person visit with him, it'll be longer. But if she does it by Zoom, it'll be 3 weeks.
All right, so. All right, the week of July 14th, that's the final date I'm giving you all.
Your Honor, if you'll give me just a moment.
Sure.
Judge, I'm out of state from the 11th to the 20th with the court.
I can bring you back the 7th or the 8th
Of
of
August,
July.
of July. I don't know if that's gonna be enough time for her to do,
When are you gonna be back?
the 20th of July. That's a Sunday, I think.
All right, Norma, set this for the 21st.
You're most kind, Your Honor. Thank you,
Sure.
sir.
There'll be no further extensions of the plea deadline date.
Thank you, Your Honor.
Is there anything else?
No, Judge, I think that will cover it. And if I get any indication from Dr. Murphy, she's not gonna make the deadline, I'll let the court know.
All right, thank you.
Thank you, Your Honor.
Is there anything else?
No, not with respect to
Oh,
Mr.
did you say you
Dixon.
need to measure him or
I
something?
do, I'll do that in the back.
Okay,
And have Mr. Flores also here today, Judge.
all right. Deputy, are you okay with me doing his other client very quickly? All right. Flores.
Judge, on Mr. Flores, I've got some discovery issues
Mhm.
and I got appointed last night
To the other case.
to another case.
And I think that's the state jail felonies.
Yes, Your Honor, it is. It's an unauthorized use.
Right, what are the discovery issues?
Yes, Judge, on the manufacturing delivery case,
Mhm.
there are 11 large files. I had made a request on May the 10th for the large files via Veripic, but I never got it. I requested it last night, and I talked to Andrew about it this morning, and Andrew's got a advocate working on copying what they can for me right now.
Okay, I think you're probably gonna need a drive or something if it's too big.
I think so, Judge. I got 4 drives out in different cases right now, so I've got to get another drive.
All right,
And I told him I'd be back by Friday with the drive,
all right, so I'm gonna recall this for discovery for July 21st.
July 20th. Thank you, Judge.
You're welcome. All right, do you have any questions?
Is there a way I could get involved?
You'll need to speak to your attorney and your attorney can file whatever motions in the court will hear it. All right,
Judge, I'll follow motion.
all right, thank you.
Thank you, Your Honor.
Flores.
Okay, that's, I did that.
Oh, and counsel on
Yes, ma'am.
Flores, can you make sure that the attorney has the discovery on the state jail if there's something that you were given?
I talked to him about it. So they did turn over about 800 gigabytes. However, it was a mistake. The discovery I was given was on some murder case.
Ah,
I
okay.
think there was a JN switch up or something.
Okay.
So they're looking into it. They said, yeah, definitely a mistake. I don't think there's any additional. I think it just got mislabeled.
Okay,
But yeah, if I hear back from IT that there is more, I'll let them know.
all right. Wait, put this in here. All right, just give me a moment.
Transaction, yes.
Natasha Manning. Natasha Manning,
Present on her behalf, Judge.
yes.
This is the individual who has her young child with her. I explained to her in the future, she needs to make arrangements. It's essentially her first court date after her matter had been indicted. So I conferred with the state on this one, Judge.
Mhm.
So due to the nature of the charge, there's a lot of discovery. It's quite voluminous. There's over 30 videos as well as a number of reports from ACS. At this time, I don't see an autopsy report done as to the that's the subject matter of this case. So I'm requesting just a 2 to 3 week reset in order to properly vet all the discovery, make sure nothing's missing, Judge.
Norma, I need 3 weeks, please.
That works for me.
All right, so just 1 moment. Who's the prosecutor on this?
Uh,
All right, Norma, Manning, that's gonna be, of course, recall for the 17th.
Oh.
For discovery. Yes.
No, I don't feel should be, but it's on bottom. That's the. I should do it like that. That's fine. I'll do Joe. Actually, well, it's not here.
Well, if you do, then I'll swap it out.
And the lower page is Manning. Oh, page 6, Judge. Thank you.
Your lot of stuff.
That's sense.
Richard Ibanez.
Present on his case also.
Yes.
Most kind
Where are we on this case, counsel?
So with this one, Judge, with regard to discovery, we believe that there's some outstanding portions at this time from Leon Valley Police Department. I know it's a smaller municipality within San Antonio, so their system isn't as automated in terms of uploading videos. In referencing the discovery, there's one PDF file with some reports as well as one body worn cam video. There, in our estimation, maybe believe missing photos, missing videos when he was taken into custody with regard to the warrants, and a report thereafter to see if he made any statements or not. So all that stuff is outstanding. I did, Your Honor. Yes, I communicated that over to them. They said that they were going to reach out to Leon Valley as well as U-Haul to see if they can get some additional pieces of information, evidence. At this time, we believe it's lacking, that they can't necessarily prove their case. So I know that they were on board as well with having a little bit of time. If perhaps the court saw fit to reset it to July 17th, 3 weeks, in order to afford the state some time to do that, would appreciate it, Your Honor. Set it on the same date if you could.
July 7th.
Okay.
So once you sign the reset, excuse me, seeing your attorney will do the document.
Thank you, Your Honor.
And what page is he on? He's on page 4. Thank you. Who's here? Noah Guerrero?
Good morning. Good morning. Judge, we have submitted the PTD agreement.
Okay.
And I'm requesting, can we reset for July 30th? I have the 29th and the 31st. She told me to ask you because she said the 29th or 31st is 30th. Okay.
July 30th.
Yes, Your Honor.
All right, go with July 30th. Yes.
Okay. Thank you, Judge.
Just like what you find a recess on your. Okay, fine. Thank you. Bill Grant? Mr. Grant, how are you doing?
Doing all right.
All right, counsel, did your client want a bench trial or a jury trial?
Jury trial, he wants to hire another lawyer on it, Your Honor.
All right, so you want to hire another attorney?
Yes, ma'am.
And how long is it gonna take you to hire an attorney?
I hired him like a couple of days ago. And
Oh, you've already hired an attorney?
uh-huh,
And who is this attorney?
I'm Michael Sawyer.
All right, so then, and has he filed a notice of retained counsel?
Yes, ma'am.
Oh, then defense, you're excused.
Thank you, Judge.
Thank you. All right, just have a seat. We'll wait for your attorney to appear.
All right, thank you.
They're not ready on this. Matthew Insuriaga. Hello. Hi, how are you doing?
How you doing?
Let me find you on the docket. All right, so docket here starts at 9 a.m., not 9:05, 9:15.
Yes, ma'am.
You understand?
Yes, ma'am.
So why were you late?
I was in the wrong courthouse.
All right, so you should have known this is the courthouse you need to be in because you've been here twice before.
Yes, ma'am. No, I just came from the other side, so I thought I was in the right.
Well, let
place.
me explain something to you. If I were not here, and if there were another judge here, you know what they would do? Take you into custody and give you a remand without bond. There are other judges who sat for me before, and when they call your name and you're not there to answer it, and they're calling the docket, even if they have not finished calling the docket, they would take you into custody. So this is very important, and you need to make sure you're on time. You understand?
Yes, ma'am. Apologies.
All right, Ms. Ferguson, set this for the second week in July. Your attorney is currently in a jury trial.
Okay. Yes, ma'am.
All right, July 8th. Once you sign the reset form, you excuse and make sure you're on time next time, okay?
My apologies.
You're welcome.
Okay, very good.
All right, thank you. Who is here on Vanessa Rubio? Hello. All right, are you all ready to proceed?
No, Judge, I need time to get some medical records from her. It's gonna be an open plea to the court.
All right, so if you want to enter your plea now, and then I can reset it for records, but we were here in May for medical issues with your client. And so
Right, that's
now,
what we need.
Yeah.
Those are the records that we need to get.
all right, if she wants to enter her plea now, and then I can reset it for whatever records you want to obtain.
Yeah, let me talk to her.
All right, sure. Is there anyone else ready? If I have not called your case, it's because I don't have your file.
Oh, I'll get that.
All right, what case?
For next week. It's someone after.
All right. Hello. Okay. 6. All right, so counsel. I know this has been pending for jury trial.
Yes, ma'am.
As you know, next week is a short week because it is 4th of July.
Okay.
And so I don't know if you would agree to recalling this for a different date. If you still want it for the 30th, but my intention was to give everyone a chance to be with their families and everything. But if you want to keep it for this date, we will keep it for the date for jury trial.
We can move it. I think we're set for July 1st, which would even be a little bit closer. Juveniles pressed me to trial on a case over there. We
Okay,
have a kid with a parent with an immigration issue, so they're trying to get us in under the bar before
all right.
something happens with ICE. So more than likely, I'm gonna be in trial on Monday, and we'll probably be done by Tuesday or Wednesday, but still, I'll be in trial elsewhere.
All right, so Ms. Ferguson, what do we, and I'm assuming you're not going to want to do trial immediately after that trial.
Yeah, I mean, this is my third week of trial in a row, so I'm gonna be a little bit tired.
If you'll speak with Ms. Ferguson, is your client on bond or in custody?
She's on bond. I have good contact with her.
All right, if you'll speak with Ms. Ferguson on a new trial date,
Good deal.
and if y'all want a bench trial, I'm here.
Problem is Zach.
Yeah.
So even if it's guilt,
Yeah.
I kind of have to go to a jury.
No, I understand
Otherwise,
with
yeah.
the punishment.
Yes, ma'am. And I researched it. You can't get,
No, you can't.
no, there's no way around it. I'm sorry. I'm gonna be out of the country from August 1st, 15th,
Oh, where are you going?
Alaska, going salmon fishing.
Okay, why do you call that out of the country?
Because it's not in the proper continental US. Also, I'm going to Canada, and we're going into Canada too, keep
Oh, okay.
territory.
All right.
So. That should work. Yeah. Good.
Okay.
That's awesome. I love Alaska. I love Canada. Sorry, I'm fine. We're gonna be, I'm not sure who we're.
No, let's keep it for the 22nd.
No. Well. And they threw the open drink, I mean, drinks, but they put the open drink package. Yeah. It's possible. I have 63 right now.
Hello.
Hey, Judge, do you have a Gilmore up there?
So who?
Do you have Gilmore up there? His attorney is in trial.
I don't have your one.
His attorney is in trial. We were doing this as a hearing to use early termination
Mhm.
consideration.
Oh, we can go ahead and do it.
Asking for a reset. So that his attorney is present, the state is opposed.
Okay, let me see what, all right, let me look at it and see what it's about. Just give me a moment. Okay, on Gilmore, I don't have a docket sheet. Yes. It's 2024. Oh, just one second. It's towards the very back. All right, State on Gilmore, you're opposed to early term? All right, have y'all spoke to the complainant?
Yeah,
And what does the complainant want?
she's not one early term.
Okay. All right, well, his attorney, Mr. Gilmore, if you've come forward, please. All right, Mr. Gilmore, your attorney is actually in a jury trial, so I'm gonna have to reset it so that he can be here. And present whatever arguments he wants to the court. I mean, you've heard the state, the complainant does not want you to have early termination. That doesn't mean that I'm not going to grant early termination. These are just all things that I consider when making a decision. So we're going to what we'll do is, because it's your attorney's motion, we'll just let the court know when they want it set and we'll hear it, okay? And then your attorney will get in contact with you with the new date. All right, thank you. Thank you so much. No, you don't. What will end up happening is your attorney will call us or come by and say, can you place this on the docket? And we would have released you earlier, but we just received notice that that your attorney was in jury trial.
Yes, ma'am.
All right, so just get in touch with him and he'll put it on the docket and we'll set it.
Thank you.
Excuse me, sir. I'm being told that it may have been filed by probation, a request for early term.
Yes.
All right, so what we'll do is we'll still reset it. Just call your attorney still. All right, thank you. All right, counsel, are you ready on Vanessa Rubio? All right, the court is calling 2023 CR 4281A State versus Vanessa Faye Rubio. Can I have parties announced?
Megan Galloway for the state.
Alfonso Otero on behalf of Ms. Rubio.
Are you Ms. Rubio?
Yes, I am.
All right, did you review the document entitled Motion to Revoke Community Supervision and State's Motion to Supplement Pending Motion to Revoke Probation with your attorney? Did you understand it?
Yes, I did.
Are you the same Vanessa Faye Rubio who was placed on community supervision in 2023 CR 4281A for the offense of theft of a firearm on August 7, 2023 for a term of 4 years? Is that you?
Yes.
All right, state.
Violation of condition number 4 in Bear County, Texas, the defendant Vanessa Faye Rubio did then and there fail to report to the supervision officer as directed for the months of April, May, June, July, August, September, October, November, and December 2024 in violation of condition number 4.
How do you plead to that? True or not true?
True.
And violation of condition number 4, in Bear County, Texas, the defendant Vanessa Faye Rubio did then and there fail to report to the supervision officer as directed for the months of January, February, and March 2025, in violation of condition number 4.
How do you plead to that? True or not true?
True.
And we'll waive and abandon the remainders, Your Honor.
Any objections?
No, Judge.
All right. Did you understand by pleading true to violations 4 and 4, the court could find it true, grant the motion, and sentence you up to 2 years in the state jail facility?
Yes.
Knowing that, do you still wish to plead true to violations 4 and 4?
Yes.
All right, the court will find violations 4 and 4 true. Is there an agreement or no?
No,
No.
Judge, it is the case we talked about that we
Yes.
need the
No,
medical.
I remember. I'm just trying to see if there's an agreement. All right, we can go off the record. So here's the thing. I did receive information that your client was in the hospital. I think the state is aware of that as well. So the real question is going to be when? And are we saying that she was in the hospital for these months that she did not report?
She lost her sight for a while, so we need the documents to see exactly what happened, so the court can consider how that may have impacted.
I mean, I'll consider it, but we go back to whether or not these months that you've pled true to of not reporting, whether or not this was the time you were in the hospital. I mean, that's what I want to know. Because if this is not the time you were in the hospital, then you're being in the hospital, that's just sort of mitigation, but it's not really an excuse for not reporting. For example, April through December 2024, if you're in the hospital for all of that time, then the court will understand, okay, she can't do things because she's in the hospital. But if you were not in the hospital for those days, then the question that I would want, and I'm giving you all this information so that I can get this type of information. The question I would want to know is, where were you and why were you not reporting? And it goes the same for January, February, March 2025. Where were you if you were not in the hospital? You understand?
Mhm.
So if you were not in the hospital during those time periods, you probably need to let your attorney know, because he's going to be seeking certain information to show that either probably that you were in the hospital or that you had some type of medical issue that you were overly concerned about.
Mhm.
And that's why you didn't report. But for the court, it's easy to pick up the phone to call somebody and say, hey, I'm having medical issues. So this is the type of information I'm going to want. But if that information is not there, then don't have your attorney spinning his wheels to get information that does not exist. Do you understand?
Mhm.
Okay. All right. So does this information exist?
I believe that it's considered a factor, yes.
I'm sorry.
I believe it's considered a factor.
All right. So, and you're not an oath. So my question though is, these dates where you pled true to not reporting, were you in the hospital?
I was not in the hospital, no, but I was seeking care for it was, it was a big issue at the time. It was concerning for myself, and I spent more time considering that. I did mess up and not call, and that's my fault. I pled true to that.
Okay. And so my understanding, you all don't have an agreement,
No.
and what would you be asking for?
Well, just give.
No, I mean, if you
Oh,
were,
well,
if you're just, I'm just trying to figure out where we are, so I'll know.
Yeah,
What
yeah,
would you
yes.
be asking for?
To keep her on probation, there's ISF recommendation, or whatever the court means necessary to bring the defendant in compliance, and having an opportunity to continue her treatment for her eyes.
All right, and state, what would you be asking
We're
for?
asking for revocation and 2 years in the state jail.
Okay, all right, so now I know where everyone is and you know where everyone is. So how long is it gonna take for you to get the information you're seeking?
I think the jail has him. I mean, I probably can try to, she's going back and sign a HIPAA for me. And once that's done, I just contact the jail and see what they have for me.
So does the jail have this information?
Yes, because I used UT Health for all of the treatment before I was incarcerated as well. So they have access to all the records.
Okay, So then maybe if you have one of the nurses there, if she signs HIPAA, then you can have the nurse Zoom in and testify if you want to do that.
That'd be great, Judge, yes.
All right. And you say you have vacation. When would this be?
It's on the 26th to the 30th. This Thursday to Monday. I mean, I can cut it short and come back on Sunday.
No, I mean, Norma, can you recall this for July 8th? All right, is there anything else?
Nothing, Judge.
All right, and then what I discovered when I was a defense attorney, if you just call over to the jail and ask to speak to the nurse, once you sign your release, they should be able to give him the information very quickly, but you have to do your part, okay? And counsel, if there's an issue with communicating with them, just let me know, and if you want me to see if I could help expedite things, I'll do that.
Yeah.
All right, thank you.
I'm sorry, Judge. You told me, this reset.
Yes, it's gonna be reset till July 8th. Defense counsel wants to see if he can obtain some medical records from the jail. Oh, I have it. Just give me a moment. That one I'm thinking about, counsel,
Okay.
because it's an old case. I'll double check. All right. William Barnes, come forward. All right, so state, your witnesses for this case, are these out-of-state witnesses or out-of-county witnesses?
No.
All right, so they would be available beyond this week?
I would think so, yes.
Okay. In just one moment.
I know, we can go, but it's a charter, we booked like
It's
a
not-
long time ago.
See, a long time ago, but see, this is what I mean. Everybody agrees on these jury trial dates. I send you all off to Norm and say,
No, this case was set for last week.
and I'm like, ah.
And we were before Judge Angelini, and you know what happened.
Mhm. Yeah.
He picked another case.
Judge, they do have, jurors on the 30th, the first and the second.
All right. So we would do jury selection on June 30th. And this will be the only case on the docket, so this will be going.
Okay.
All right, so we're rescheduling you for June 30th. Your attorney has a vacation. And I always tell people, don't get upset with your attorney for having a vacation, because everybody needs their mental health breaks and to just get away from all of this. There was a time when I would never do a vacation. And a defense attorney told me, he said, Stephanie, you should do a vacation with your family. What are you doing? I'm like, I got to keep working. And he said, Stephanie, if something were to happen to you and you were to die, he said, I would be very sad. But he said, you know what's going to happen? I'm like, what? And of course, you all in your feelings, you're like, they're going to shut down the city. It's going to be a day of mourning. He said, what they're going to do is they're going to say, that's such a shame. And then who's taking our cases? And they're just going to give other people your cases. So attorneys need their mental health break, because attorneys deal with a lot, especially when you're a solo practitioner and you don't get a break. So I'm going to let him enjoy his fishing. Hopefully he will catch something. Yeah. You'll have to show us a photo of you holding the fish.
Oh, yeah.
All right. So we're going to come back on June 30th. All right. And is there anything else, counsel?
Nothing else, Judge.
All right, so we'll bring you back on June 30th. You'll be brought just for trial. We're going to call up the jury on Monday. State,
We're gonna do it early in the morning, I guess.
yes. State, if you'll make sure that you have your witnesses and be ready for on Monday.
For testimony to begin on Monday?
Yes.
Yes, ma'am.
And so what will end up happening is, because they have to qualify jurors, we probably won't have a jury out in the hallway till 10 at the earliest. But then we're going to do jury selection. Then right after jury selection, we'll come back in the afternoon for testimony. All right.
And there's the two pre-trial motions, it's just a limine and 404B. It's very simple.
All right, what's the motion in limine?
There's a limine and a 404B.
All right, if you'll confer with the state over that, what I can tell you is I don't know anything about your case. The only thing I know is what the charge is. So with regards to motion in limines, which means the defense, there's some things that he maybe doesn't want the state to mention before the state gets ready to question any witnesses about that or elicit any testimony. I'll have the jury step out, and then I'll be able to hear argument, and I'll know better what this case is about and what both parties say and the facts are, okay?
Sure.
And then the 404B,
Mhm.
If you'll talk to the state
I'll
and,
talk to them. I think I have their notice.
okay.
Okay.
All right, thank you.
Thanks, Judge. Maybe excuse their
Yes, you may be
texting me
excused.
from the
Yeah.
crowd call. Monday.
She's going to sit there.
Yeah, still not done.
Awesome. Welcome. Have a seat. What's your name? Hi. Well, welcome to the White Center. And just have a seat here and I'll tell you what's happening. Okay, all right, thank you. So right now, cases are being brought before me. And we're supposed to be scheduled for jury trial today. It may or may not happen. It just depends on who's ready for trial. So what grade are you in? Oh, awesome. Well, welcome. And what school are you attending? Okay, all right.
You're on.
Yes.
Sorry. May I approach from Baltimore and chocolate?
Let me see. Okay, just give me a moment. Let me put this in the system.
Yes, sir.
And Norma, what page is Barnes on? All right, thank you. And on Barnes, which case are you all, are you proceeding on the assault,
Yes, Your Honor.
the assault choking?
Yes, Your Honor.
Okay. And what's gonna happen with the other case?
Your Honor, at that time, we could do it afterwards, or, we just have to pick one to go on, so we're just doing the choking first.
All right, so why did you, I thought this was the other case. Why do y'all think this is gonna last beyond the time frame we're here? I mean, shouldn't this defense on this assault choking case? How long should it, are you, if your client were found guilty, are you going to the court for punishment or the jury?
The jury.
Okay,
Oh, Your Honor, I think we considered and thought we would be picking on Tuesday, and so it would last until Thursday. But if we are, no, because it's next week on Monday. Yeah. So if we're picking next week on Monday and starting on Monday, the state should be done by Tuesday afternoon.
okay, so if y'all were to do jury selection today, y'all would be, when do you leave?
I leave on Thursday.
So this should be done, right? If we were to do jury selection today?
If we were to do jury selection today and start Wednesday, the state has 5 witnesses, one of them being the complainant and the defendant on.
I mean, we would start in, on the morning.
But I'm sorry, defense counsel also may have witnesses. And so I don't know that we could say that we would be finished with state's case in chief, defense case in chief, jury charge conference, closing.
And deliberation, render a verdict.
Because he's gonna be gone on Thursday, was my understanding.
Yeah, so that's why I just felt it'd be safer at the trial lease run until Thursday. So the jury, the closings on Thursday and give the jury time to deliberate Thursday.
Okay. Do you still want to keep it for the June 30th?
Yeah, I have to go on Thursday. I'm
No
cutting
problem.
Monday short, so it's better to cut Monday short.
No problem.
Yeah.
I thought y'all were going on the other case.
Okay.
All right, thank you.
Thank you, Judge.
All right, and who is off docket?
Actually. Alderman Topper, Your Honor.
Okay.
I have conferred with the defense attorney, Mr. Dominguez, and I know the court wanted to bring both of us in today
Mhm.
to discuss the case for next week. I believe it's set on
Yes.
July 1st. And he did just say I could approach on my own.
Okay. All right, so. Why is this coming up as no match found? Just give me 1 second. Topper. Ah, there it is. All right, so it's set for jury on July 1st.
Yes, sir.
And Norma, can you just move it for the following week and we'll see what goes?
Thank you,
And
Judge.
so we'll put it on July 7th.
Thank you, Judge.
You're welcome.
Your Honor, I do have to check. We do have several lay witnesses. If they are not available, can we reapproach the court?
Mhm.
What do we need?
Just. Someone.
Okay, wait a minute.
All right, so this is a criminal felony district court. So the cases that we hear in this court are felonies. And felonies are cases where someone can be sentenced up to two, at a minimum, up to 2 years. So when you go to misdemeanor court, the most that they can be sentenced to is 1 year in the Bear County Jail. So here, anything over a year sentence, those are usually the felony cases. In this court, there's a lot of drug cases, and those drug cases are usually not your marijuana cases so much. It's usually methamphetamine, some type of opiates. Sometimes we do get marijuana cases, but normally it's your harder drugs. Not that marijuana isn't a hard drugs, don't do drugs at all. And we get your cases involving assaultive offenses, a lot of domestic violence cases. And the domestic violence cases, normally they're in misdemeanor court. But if someone is accused of doing it more than once, usually ends up in felony court. And then we have your other serious felonies, murder cases, any type of sex cases involving children. Those are the cases that we get here, and anything that's aggravated. So when they say that a case is aggravated, sometimes it has to do with the injuries caused that make it aggravated, but sometimes it's because someone has displayed or used a weapon. And in felony court, and according to the law, anything can be used as a weapon, really. It's just the manner of its use. A gun, a knife, it's easily to see. But for example, this cup, it can become a weapon and make something aggravated if I'm hitting somebody with it and injuring them with it. They can say, yeah, I've used this as a weapon, so that makes it aggravated. So everybody charged with a criminal offense is entitled to a defense attorney. So in this court, you have people who are defense attorneys, you have people who are prosecutors, and the prosecutors are the people who have sent cases for indictment. People always say the prosecutor is the person who's trying to prove someone guilty and send someone to prison. But legally, their job is supposed to see that justice is done, whatever that may be. Sometimes people may say justice is not charging somebody for a crime, even though you know they committed it. Sometimes justice is you feel as though, someone committed a crime beyond a reasonable doubt, and you feel as though justice is for that person to go to prison, or maybe justice is for that person to go to probation. A lot of times in courts, plea agreements are worked out, so that means there's no jury trial. But if there's a jury trial in felony court, normally there are 12 people who are sitting in the box, and those 12 people will hear evidence and they get to decide whether somebody's guilty or not guilty. Sometimes people say, I don't want a jury to hear it. I want for you to hear it, in which case it's a bench trial. And then I will hear whatever evidence is presented. Now, usually people enter into plea bargain agreements and they're placed on probation. The lady you see in the green, that's Bashan Abrams. She's our probation officer. So she'll let the parties know where they go for the conditions that I've set. And when someone's on probation, number one thing, don't commit any new crimes, right? The other thing is you always have to report. So right now, they've handed me these cases. I'm going to make sure that everybody has their discovery. And the defense is entitled to discovery, because you want to know if the state is charging you with murder, you want to know, okay, what do you have to prove that I committed this murder, so the attorney can talk to them? Okay. All right, Troy Trevino. Why do I have this case, Troy Trevino? Okay, and where is Trevino?
He's right here.
Yes.
Forget where I'm standing.
Oh, you're right here?
Right.
All right. Yes.
Yes, Judge. So my client has he has several cases, one with several with family violence and several with criminal trial division. They are working together to try to get us a comprehensive deal and first offer. This is a first setting. even a 2-week reset, just to give them some time to get us a first offer. We come back and see what we can do from there.
All right, Ms. Ferguson, if I can have a 2-week reset on Trevino, please. And just set it as discovery. And state, will you have an offer by that time?
We should, yes, Your Honor. Is
All
it
right.
possible to do the 9th? Only because the 8th is getting complicated. Could we do the 9th the very next day?
All right, the 9th. Do it for the 10th then.
Thank you, Judge.
The 10th, Norm, is that okay? Yes. All right, we'll bring you back on the 10th. Do you have any questions?
Thank you, Judge. May we excuse?
Yes.
He's in custody. Yeah.
All right.
Yeah.
Sorry about that. Their staff, not whole staff. Well, that.
And Norma, what page is he on? All right, thank you. Oops. And he has 2 pages. I mean, he has more than 1 page.
Yeah, we just got back on the other ones.
Okay. And who is Mr. Sawyer waiting on? Because I don't have it. And I think I returned that file back because yeah, that file was returned back. Let's hear on Leon Small.
I am your. Yeah,
Yes.
Mr. Small is in the custody of the Bureau of Prisons, or at least in federal marshal custody. He's got a federal case. I brought the court, the docketing sheet on his federal case off of Pacer, as well as his federal indictment, as well as, there's an order of detention, which is not contained in there, but there's reference to it. He was detained without bond over there. And I think his next, if you look at the very back page.
Yeah.
There's an order, setting a plea deadline. Yes, ma'am. So I think I'm not representing him on the federal case, but I think, I hate to use the word artificial, but I don't know. I mean, these dates are certain dates for right now, but
They may change.
it will change. I believe.
Ms. Ferguson, I need a date in August for Mr. Small, late August, please.
And Judge, I hate to ask you this, but and anyone that could help me on it, is he showing up on bond, or is there a way I could make an oral motion, or does the court need me to file a written motion to go ahead and go off his bond, just so at least he's accumulating credit?
What I can tell you in this court, I mean, if you want to do that, of course, the court will do that. But in this court, your client has been in custody and he hasn't made bond. And if for some reason he were sentenced on this case, I would give him credit for the time that he's been in federal custody while this case was open.
Very well, Judge.
Because sometimes he may be found not guilty. Then he's like, I don't have a bond.
Right.
All right, what date, Ms. Ferguson? All right. Is there anything else, counsel?
No, ma'am, Your Honor.
All right, good seeing you.
Pleasure seeing you.
All right.
Thank you, Judge.
You too. All right, so with federal cases, the federal court will not release a defendant to come to state court until their case has reached its conclusion. And there's nothing we can do about that. So we just have to wait until they finish. Sorry, that was mine. Trying to try it again. Joe Grant? Yes.
Your Honor, Mr. Grant is on today's docket. I was
Yes.
just hired yesterday at 5
Okay.
o'clock.
All right, Ms. Ferguson. I need a jury trial date for Mr. Grant, and if it works out, then there will not be a jury trial. So can you set this in July, please? Criminal Trial Division. It's a possession case. It shouldn't take that long. All right, July 22nd.
That's good, Your Honor.
All right, and that'll be your jury trial date and plea deadline date, and you can ask your client if he would like a bench trial.
I will do that, Your Honor.
All right, and Norma, you said the 22nd? All right, once you sign the reset form, you're excused.
Thank you very much.
Thank you.
Have a good day.
You too.
Thank you.
You're welcome. All right, thank you. Who's here on Cameron Scott? For early termination. Okay.
You probably don't have that. You have two files on Mr. Scott, Judge, that 2021
Mhm.
case has already been terminated. That was,
Okay.
that's expired already. That was terminated.
Okay. So that just leaves there.
This is the 2017 cause number. Did you need a copy of the request for early term? Because
Yes.
this might be, those might be the older copies.
Okay, yes, I think it is. It's from October.
Right. Ignore the black ones and the brown ones, right?
Okay, no problem. All right, so what I can tell both parties is one of the issues with this case is he has prior motions to revoke. Am I reading that correctly?
Yes, Judge, those prior motions to revokes were years ago, some years back, 2020, I believe.
Well,
And based on that motion to revoke, he was placed on deferred adjudication in that case for 3 years, and that 3-year term is coming on. He's already successfully completed that term.
okay.
During that motion to revoke, he was extended 5 years on this probation term.
Mhm.
So that's what happened with the motion to revokes. Or the latest one,
So basically, he has about 2 more years on this.
2027, Judge. We have sent, this is the third request for early termination that we've sent in. One in February of 2024 and one in November of 2024.
All right. And State, have you reached out to the complainant?
We have, Your Honor.
And what is she requesting?
Your Honor, at this time, the complainant is requesting that the defendant remain on probation. We did speak to her about several instances that have occurred after these NTRs. One being very shortly after he was released from GPS on the NTR in 2021, he went over to the complainant's residence and was knocking on the door and stayed outside of her residence for
And
quite
what-
some time.
What year was this?
It was in October and November of 2021 after the last NTR. They did not report that to the police because she did not want any more drama with the defendant and didn't want to just cause anything else. So she did end up just leaving that residence. And then last year, the defendant reached out to her on TikTok and sent emojis and changed his profile picture to her profile picture. And the complainant did tell us that it just seems like nothing has changed, and that he's going to continue reaching out to her and bothering her. Additionally, Your Honor, the state just looks at the defendant's criminal
Well, let me
history.
ask this. So let's go back to the TikTok thing. I don't know about TikTok and how it works really. So, what's the proof that he did that?
Your Honor, I mean, I can have, I'm just proffering what the complainant has told me. If you would like to hear from the complainant, we can do
Well, I
that.
mean, I need some proof of things that are being said instead of just people saying it. I remember this case. I remember all the cases. And I remember this case in the very beginning, there was an issue with the complainant not being cooperative. And I understand when complainants are not cooperative, then they change their mind and different things happen. But if there are reports that just last year he was reaching out to her, then I need more than just somebody saying that. I need proof of that. So will you be able to provide proof, or if she wants to come in and give testimony, she can come in and give testimony?
Sure, Your Honor, she is available. She's ready right now to give testimony if the court would like to hear it.
All right. So do you have an attorney? No. All right. And you were given a court-appointed attorney previously? Yes. All right. So we will see that you have an attorney. Just one moment.
When are we setting that, Judge?
I'll always do this to get.
I'll probably do a court appointed attorney.
Well, now here's the thing. You have to be interviewed to see if you qualify. You just can't say,
I like to be interviewed.
all right, Ms. Ferguson, if you can see if he can be interviewed for an attorney.
Yes, sir.
All right. All right, who's here on Amanda Hernandez? And then after Amanda Hernandez, it'll be Leroy Beal. No, I don't have that. Everyone, if I have not called your case, it's because I don't have your file. All right, the court is calling 2025 CR 0000174 and 2025 CR 007073. State versus Amanda Hernandez. Can I have parties announced?
Rick Pena for the state of Texas.
John Young for the defense.
And are you Ms. Hernandez?
Your Honor, it's an oddity in the system, but I have two Amanda Hernandez's right now, so I would ask that she be identified as Amanda Marie Hernandez.
You are Amanda Marie Hernandez?
Yes.
Counsel, in each of the cause numbers, did you receive all of the discovery and did you review it with your client?
Yes, Your Honor.
In each cause number, the court will find that the state is in compliance with discovery. In each cause number, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you understand it?
Yes.
Counsel, I'm sorry, Ms. Hernandez, in each cause number, did you review the documents entitled True Bill of Indictment with your attorney? Did you understand it?
Yes.
And counsel, do you waive the reading of the indictments?
I do, Your Honor.
State, are you proceeding on the indictment as presented in each cause number?
For both cases, yes, Your Honor.
Ms. Hernandez, in each cause number, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
In the cause number ending in 7-4, you're charged with fraudulent use or possession of identifying information less than 5 items. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes.
In the cause number ending in 7-3, you're charged with injury to a child or elderly or disabled person, bodily injury. That's a 3rd-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine. Did you understand?
I did.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
I do.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call and the right to remain silent. By entering this plea, you were giving up those rights. Did you intend to give up those rights and enter into a plea in each of these cases? Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes,
Do you believe she's currently competent and was legally sane at the time of the offense?
I believe she is and was.
Mr. Hernandez, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
In each cause number, the court will find that defendant has knowingly and voluntarily waived her right to jury trial. In each cause number, did you review the plea bargain agreement with your attorney? Did you understand it?
Yes.
According to the plea bargain agreement, the causes are to run concurrently. The state is taking in consideration 2024 CR 011068. In the cause number ending in 73, there's a affirmative finding of family violence. There's to be no contact with the complainant or the complainant's address. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as a primary custodial parent?
Yes.
And in the cause number ending in 7-4, yes,
I believe with the 7-3 case, there was a fine as well.
a $1,500 fine.
And I'm going to
That the
be
court is
asking
gonna
for
probate.
probate that.
Yeah,
Your
I
Honor.
will probate that.
Thank you.
All right, and then the cause number ending in 7-4. There is to be restitution to Audrey Bash, Roberto Alfaro, Arturo Olivares, and that's to be determined. Did you understand that to be the plea in each of the cause numbers?
Yes.
Defense, is that the plea?
Yes, it is, Your Honor. I have also told my client that if there is any objection to the amount that probation determines as restitution, that I will ask for a hearing on restitution with the court.
All right, state, is that the plea?
That is the plea, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes. ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
There have not, Your Honor.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 6 years. There'll be 100 hours of community service restitution, no contact with the complainants, anger management, TAP evaluation, follow all recommendations in MRT. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then in cause number 2025 CR 000174, how do you plead?
No contest.
And in cause number 2025 CR 007073, how do you plead?
No contest.
State any evidence.
As to both cases, Your Honor, state offers into evidence exhibit 1 with all attachments.
No objection, Your Honor.
All right, and state, have you spoken with the complainants?
We have, she's here, and at the conclusion, she'd like to give a victim impact statement.
All right, state, you may be excused.
Thank you, Your Honor.
Did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Did you understand that by entering this plea, again, you're giving up your right to jury trial, a right to remain silent, and the right to cross-examine witnesses?
Yes.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and will review the same.
Yes.
All right, in each cause numbers, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, I know that she, even though I am retained, that she does not have any money or in her own name. I was hired by a gentleman that is a friend of hers. I know that he intends to abide by this. I've explained to her that the court normally will review a request for early termination if she completes everything she does, has indicated to me she intends to try to do that.
All right. Do you have any children?
Yes,
What are their ages?
they're already older than 18.
All right, what are their ages?
25, 19, 18. Yeah, I don't even know.
You don't know?
I don't.
All right.
He wasn't in my life.
All right. When's the last time you were employed?
Prior to coming into jail, so, about 4 months ago.
Doing what?
Yeah,
And who were you caring for?
my best friend and 2 neighbors of his.
All right, who is Oscar Lara the third to you?
Oscar Lara.
The person you were in the vehicle with when all of these cards were found?
In the vehicle, I was by myself.
Yeah. According to the stipulations, it says officer observed a male and female enter the Lincoln, and that's the Lincoln vehicle. Yeah.
Oh, that's Paul.
No, there's a Oscar Lara the third. That's a different person. And you also have Paul Vasquez Jr.
Yes, Paul Vasquez is the one that was in the driver.
All right, so who is he to you?
A person I hung around with.
And who is Oscar Lara the third to you?
That I don't know. I don't know that person.
And who is Roberto Alfaro to you?
My ex.
All right, when's the last time you used any type of drugs?
About 7 months ago.
And what do you use normally?
Heroin.
Okay.
I've been on Suboxone that's how I got off of it prior to coming over here.
All right, I understand when people say they're off of drugs and then they get on another drug, so they
Yeah,
won't use the
off of that,
drug.
But I had to stop, but yeah, I know.
I mean, it's still a drug,
I
right?
understand.
Do you have any violent history?
No.
All right, this is what the court is going to do. In cause number 2025 CR 000174. The court is finding there's sufficient evidence to find you guilty. The court will defer finding of guilt. The court will sentence you to 5 years deferred adjudication. This will run concurrent with 2025 CR 007073. Taking into consideration 2024 CR 011068. There's to be restitution to Audrey, AUDREY Bash, BASH, Roberto Alfaro, Arturo Olivares, regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days of release, no employment as a home healthcare provider or with minors, no residing with minors or the elderly. Field visits 1 time per month until further notice. There should be a referral to felony drug court and Esperanza Court in custody. And there is to be 150 hours of community service restitution and 60 sober support meetings in 60 days. Probation, is there anything else? Is there anything else you need from the court with regards to that case?
No.
And cause number 2025 CR 007073. The court will sentence you to a $1,500 fine. That will be probated. This will run concurrent with 2025 CR 000174. Taking consideration 2024 CR 011068. There's an affirmative finding of family violence. There's to be no contact with Myrna Espinoza Portillo or Yukon Boulevard. $100 hours of community service restitution, anger management, proof of employment within 45 days, no employment as a home healthcare provider or with minors. No residing with minors or the elderly. Field visits 1 time per month until further notice. A referral to felony drug court and Esperanza Court. That's to be done in custody. And in each cause number, there's to be a TAP evaluation in custody. Follow recommendations. And there's to be 60 sober support meetings in 60 days. Probation, is there anything else? Is there anything else you need from the court in regards to that case? In each of the
This cause number.
the term on this cause number is 6 years.
Your Honor, can I ask you to reconsider the referrals to both Esperanza and drug court in custody? I know that my client, part of her reason for entering these plea bargains was in order to get out of jail.
No. You need help. You have a drug or alcohol problem. And your drug or alcohol problem is what brought you here today. You understand?
Yes.
All right, did you review the documents entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes.
Because these are plea bargain agreements, because I followed your plea bargain agreements, and because you waived your right to appeal, you do not have the court's permission to appeal. And cause number 2025 CR 007073, because there's an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. In this court, communication is key. If there's an issue, you need to let your probation officer know about it. If you feel as though they're not addressing it, you can always come back to the court. Do you understand? All right, so here's the other thing. You're not allowed to be a home healthcare provider. You're not allowed to take care of the elderly. You're not allowed to take care of minors. If you do any of those things, it's going to be a violation of your probation and a motion to revoke is going to be filed. You also are not allowed to live or reside in any household where there are minors. Do you understand? And where there are elderly persons. You understand?
Yes.
All right, good luck to you.
Your Honor,
Yes.
the definition of elderly is sometimes a little fuzzy. My interpretation of that is it's a person over 65 years of age.
All right, so
When
let
they
me
cannot take
let
care
me
of themselves.
clarify. How old are you?
I'm 45.
You're 45. You cannot, Vashan, for her, 45 is 10 years older than whatever she is. So you're not allowed to live with anyone who is 55 or older. You understand?
Okay.
All right, thank you.
Your Honor,
And my understanding, there's a victim impact statement.
Yes.
just for your Honor's edification, if it's okay, the victim would like to give it in Spanish.
Here's.
Do you speak Spanish?
If I do, yes.
All right, so she wants to speak to you in Spanish.
No una vez, pero varias veces, tú lo sabes, Amanda. No te quiero ver nunca jamás en mi vida, por favor. Oíste, sí, porque perjudicaste mi vida, parte de mi casa, la destruiste, quebraste mi televisión, mi estufa, mi hielera, todo hiciste en mi casa. Yo tenía que callar. ¿Sabes por qué? Porque mi hijo me decía que no te echara la puerta.
yo ya no aguantaba, yo estaba ya para reventar, yo ya estoy mala de la presión del corazón. Me diga, dice que yo llegara hasta ya estoy cansada, no te quiero ver nunca más en mi vida. Y agradezco a Dios que ya se terminó la pesadilla y aún así no duermo, vivo con mi cambio de cama, del cuarto. ¿Por qué? Porque tú me sentenciaste, que tú sabías dónde yo duermo para llegar una noche. Alguien va a llegar a visitar, como me mataste este hombre 3 veces. Ya estoy cansada, Amanda. Prefiero nunca más verte en mi vida, por favor. Agradezco el tiempo que me dieron para expresar lo que yo siento en mi corazón, el mal que causaste en mi vida. Y aunque no te importe, es verdad, y Dios lo sabe, sabes, todo el mal que me causaste, te aprovechaba porque Robert me ha dejado, te volteaba a comprar, pero eso se acabó.
Just one second. Yes.
Yeah.
Yes. Yes. Hello. I'm doing okay. Okay, hi, so he's back for you. All right. All right, thank you, you too. Who's here on bill?
Here, Your Honor.
Court is calling 2025 CR 002530, State versus Leroy Bill. Could I have parties announced?
Andrew Harris, Tatum, the state.
Fernando Ramos for the defense.
And are you Mr. Bill?
Yes, ma'am.
And you all are here to enter a plea?
Yes, ma'am.
All right, counsel, have you received all discovery in this case and did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Bill, did you review the document entitled Application for Community Supervision or Deferred Adjudication with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Judge. Waive the repeat offender enhancement allegation.
Any objection? All right, Mr. Bill, did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right, you're charged with unlawfully carrying a weapon with a felony conviction as a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison? Did you understand that? if you were not to do well on your probation, then I could sentence you up to 20 years. Did you understand that?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yeah, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
He has been evaluated by a psychiatrist, determined he is competent, Judge, and I agree with that.
Mr. Bill, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
All right, according to the plea, punishment is to be assessed at a cap of 8 years in the prison, and the state is silent on your application. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
Did you understand by signing that to waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court? Did you understand?
Yes.
Counsel, are there any such motions?
None, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Contained in Exhibit 1 and attachments.
No objection, Your Honor.
All right, state, you may be excused. Did you review the document entitled waiver and consent to stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
All right, off the record. There is no judgment in here. All right, we're back on the record. All right. Did you review the waiver and stipulations with your attorney? Did you understand it? And did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same.
May I approach, Judge?
Yes. Any objections to the amendment?
We have none, Judge.
All right, we're off the record. So here's my question. I always say, I don't know all of the law. But is it illegal to smoke in a city park?
I believe it is, Your Honor.
Well, I mean, let's not go on beliefs.
I don't know.
Is there a law? Does any attorney know? We're off the record. Does any attorney know whether or not it's illegal and arrestable offense to smoke in a city park? I don't know that off the top of my head. All right, so for both parties, the first hurdle I need to get over to see whether or not there's an issue here is for whether or not it's illegal to smoke in a city park, because they're saying that they arrested him for smoking in a city park, and then that led to everything else. So I don't know the answer to that. So if you all can come back at 1:30.
Judge, my wife has been very sick. I've been up all night with her. She had spinal surgery about 30 months.
Are you able to appear by Zoom?
Sorry,
Are you able to appear by Zoom?
I didn't hear you.
Are you able to appear by Zoom?
Yes.
All right, so you can come back by Zoom.
Yes, ma'am.
All right, if somebody could make sure that Mr. Bill is back by 1:30, and I'll research to see that answer because I don't know that one off the top of my head.
Thank you, Judge.
All right, thank you. No, it's probably best that you not say anything. All right. All right, who's here on Vincent Savage? Norma Bill is gonna come back at 1:30. All right, so in this case where you're on
Yes,
discovery,
ma'am. I conferred briefly with Mr. Edelman.
everyone, please whisper.
I was told that it's been re-indicted. They don't have the file down here. They're looking for it. So I haven't had a chance to review it today. I also don't, as of now, I don't know. They're still looking into whether or not they've spoken to a victim, so.
All right, Ms. Ferguson, I need a 3-week reset date, please, on Savage. All right, July 10th.
Yes, ma'am. Thank you, Judge.
All right, we'll come back on July 10th, sir.
Thank you, Judge.
I just sent you an email, Judge. Thank you. Who is here on Ricardo Vargas?
Hello, Judge.
Hello. So today is plea deadline date.
It is plea deadline date. However, Judge, there's one other discovery matter. I haven't looked at the body cam that I
Okay.
needed to, and I know I needed to do that last setting, but I haven't got it done.
All right, Ms. Ferguson, can we recall this in 3 weeks, please? All right, that will be your final plea deadline date.
Thank you, Judge.
All right, anything else, counsel?
Nothing else, Judge.
All right,
Tell
once
me-
you sign the reset form, you are excused.
All right, thank you.
You're welcome. And what page is he on, Norma? Ricardo Vargas. All right, thank you.
Judge.
Oh, I'll deal with that in a moment. Let me finish this because they're coming back in the afternoon anyway. But I appreciate you. Dorian Camarillo. Hello. All right. Hello. So on this one, we're still doing discovery, correct?
Oh, that's correct. You got extra change going.
Yeah, sometimes. It reminds me of, every year we would watch the Ten Commandments. Oh, no, not Roots, but Ten Commandments every Easter. And you know what he said? If he a myth, bring him to me in a bottle. If he be a man, bring him to me in chains.
Like that.
Oh, that was a program. We still watch it. That's an Easter classic, right?
So it be written, so it
Be done. I'm gonna violate my final law on my deathbed and say his name. Moses. All right, so we're coming back on this case on July 24th.
That's correct, Judge.
Okay.
Now, another thing that we have is there's a motion for a bond reduction.
All righty.
So
Are you able to come back at 1:30 and I'll hear that?
you might get 1:30.
All right, Norma Camarillo is 1:30 for a motion to reduce bond. Okay. We'll pick it up. Greenwood.
Good morning, Judge.
Good morning. So how are you doing?
Hey, Judge, how are you?
All right, on this case, she hasn't entered a plea, has she?
Not yet, Judge.
All right, the court is calling 2017 CR 6646B, State versus Imari Greenwood. Could I have parties announced?
Megan Galloway for the state.
Alma Benavides from Miss Greenwood.
And are you Miss Greenwood?
Yes, ma'am.
All right, Ms. Greenwood, did you review the motion to revoke community supervision and state's motion to supplement pending motion to revoke probation with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Are you the same Amari Raisha Greenwood who was placed on community supervision in 2017 CR 6646B for the offense of theft of property $2,500 to $30,000 on January 24th, 2023 for a term of 2 years? Is that you?
Yes, ma'am.
All right, state.
Violation of condition number 4 in Bear County, Texas. The defendant Amari Raisha Greenwood did then and there fail to report to the supervision officer as directed for the months of August, October, and November 2023 in violation of condition number 4.
How do you plead to that? True or not true?
True.
State.
Violation of condition number 4 in Bear County, Texas. The defendant Amari Raisha Greenwood did then and there fail to report to the supervision officer as directed for the months of January, February, March, April, and May of 2024 in violation of condition number 4.
How do you plead to that? True or not true?
True. We waive and abandon the remainders, Your Honor.
Any objection?
No objection.
Did you understand by pleading true to 4 and 4, the court could find it true, grant the motion, sentence you up to 1 year in the state jail facility?
Yes, ma'am.
Knowing that, do you still wish to plead true to violations 4 and 4?
Yes, ma'am.
Court will find violations 4 and 4 true. Is there a proposed agreement?
Judge, there is, after conferring with probation, the recommendation is to deny the state's motion, extend the defendant for 1 year, alter and amend her conditions for SADIF, followed by aftercare, an updated TAP evaluation to be performed in custody, monthly UAs upon release, and sober support meetings.
All right, what has she done on probation? Has she done anything?
Judge, I do want to point out the top evaluation was already complete. That was done last month, and that is the new recommendation is for the SADF.
I don't think you're a good candidate for probation. Well, let me just tell you why. This is not your first motion to revoke. And it's the same thing. And in 2023, you were here for a motion to revoke. And a TAP evaluation was done. They did GPS. So, I mean, what have you been doing since then? You want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Imari Raisha Greenwood.
All right, so what have you done since you've been on probation?
I got my GED.
Oh, that's great.
Yes,
Okay.
ma'am. I am in school currently. I'm going to cosmetology school, and I enrolled in Southern University, working in my associate's degree. I understand that I messed up, and I'm truly sorry. I'm not the same person I was last time you saw me. I totally wanted to turn around in my life. I'm tired of this. I'm almost 30. I just want to move forward with my life. I understand I messed up. Yes, I just truly want to move forward. And in between time, I was going through a lot. It's not an excuse because that wouldn't make it, it didn't make a difference. But I truly am a different person, and I have stuff going on out there, and I do not want to be locked up. I'm tired of this. I just want to move forward.
Okay. All right, off the record for a moment. All right, so here's the thing. They want you to be continued. I can continue you. I don't know if you're going to be successful on this or not.
Yes, ma'am.
Or I can send you to the state jail facility for 180 days. And the reason why I'm saying 180 days is because of the fact that you've obtained your GED, and I'm glad you're on the right track, and that you have, worked towards rehabilitating yourself. So this is what you need to think long and hard about. The 180 days, you do your 180 days, you'll be done. You get credit for whatever time that you've previously done, or you're going to continue to be on probation. You're already on regular probation, which means this is already a felony conviction. So if you want to discuss that with your attorney, you can. And if you want to talk to them to see how much time she has.
She has, I believe, Judge, according to probation, she has 227 days credit.
Well, what I can tell you is, because this is a state jail felony case, they may release you from the jail, but legally what they're going to do is they're going to take you and process you at the state jail facility. And if you have credit that's beyond 180 days, they'll release you from the state jail facility.
You want to do that?
All right, so here's the thing, we're at the record. Here's the thing, it's your decision. This is what I'm telling you, and I want you to hear me and internalize what I'm saying. For a lot of people, going to the state jail facility, going to the Bexar County Jail, going to prison, that's a frightening experience, right? We don't know what's going to happen. But what I can tell you is, I'm willing to send you to 180 days at the state jail facility. State jail facility, that's day for day time. What everybody is telling me is that you've already satisfied that time. But because it's a state jail facility, normally and legally, they don't release you. They're not supposed to release you from the Bexar County Jail. Now, I've heard situations where people have been released from the Bexar County Jail, even though they're supposed to be processed through the state jail facility. What I'm telling you is legally, they're supposed to take you to the state jail facility, process you. They'll see that you have enough days for the judgment to be satisfied, and they'll release you from the state jail facility. Otherwise, you're going to be on probation in this court for another 2 years.
I'll do that 186.
All right. Are you waiving your right to appeal?
Yes.
Well, not, I guess. So if you want me to give you the 180 days, then that's something that you're asking me to do. That's something that your counsel is asking me to do. And I think the state is going to be asking me to do that. And do you want me to follow that?
Yes, ma'am.
And are you waiving your right to appeal?
Yes, ma'am.
All right. The court is finding violations of 4 and 4 true. The court will sentence you to 180 days in the state jail facility, give you credit for any time served. The court will show that the judgment is satisfied. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. You don't have probation hanging over your head, but you still need to remain vigilant, because otherwise you're going to end up right back here. Don't be celebrating, woo, I'm off of probation. Ooh, I'm out of jail, because that's when you start backsliding. So write down what your program is for your life and follow that program. And anybody who tries to stray you from that path, you need to kick them to the curb. You understand?
Yes, ma'am.
And I'll be here. If I'm here when you get out and you can't find what you're looking for, you can come back here and we can look online and find a place for you. Okay?
Yes, ma'am.
All right. Good luck to you.
Thank you, Judge.
You're welcome.
Good to see you.
You
Thank
too.
you. Be excused.
Yes. Who's here on Constance Sinwell? Yes. Good morning. Where's your client?
She's in the back, Judge, but we're just here to for a status on the doctor.
Mm-hmm.
What I was told by court administration and everybody else that I didn't know is that I guess she's just supposed to be referred to mag court and they will do the evaluation.
That's not how that's supposed to be because you're requesting a sanity evaluation, correct?
Well, I just did a notice of insanity, Judge, and
All right, so you're just doing sanity?
just insanity, not competence.
All right, so yeah, you have to file a motion for that. And they should take care of it in the magistrate's court.
Correct. Okay, so okay, Judge, well, maybe I
Yeah.
haven't done an insanity defense in
No, no,
20
no, I hear
years. Okay, I thought she would just be referred on my notice. So I can file that motion today, Judge.
Yes, awesome. And then check in with them.
Okay, we'll do.
All right, Norma, recall this for the 28th. January, July.
Judge, I'll come check in when I get that done too.
All right, thank you. Monica Guerrero, who do you have?
Judge, I have Mr. Smartle that's ready and I'm waiting for paperwork on Mr. Lara.
Okay, I don't have any document on Smarto.
Sworn in already.
Ah. Can I have a file stamp, please? And after this case, the court is going on recess and I'll have everyone back at 2.
Thank you.
Court is calling 2025 CR 005464 State versus Joseph Greenwood Smarto. Could I have parties announced?
Megan Galloway for the state.
Monica Guerrero for Mr. Smartle, Your Honor.
And counsel, is this an application?
It is not.
Okay. Are you Mr. Smarto?
Sure.
All right, counsel, have you received all discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Smarto, did you review the true bill of indictment with your attorney?
Yes, Your Honor.
Did you understand it? Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we're waiving the habitual enhancement.
And we have no objection to that and believe they're only proceeding on count 1.
Yeah, that's correct, yeah.
All right, Mr. Smarto, did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with a manufacturing delivery of a controlled substance, penalty group 1, 4 to 200 grams as a first-degree felony? Range of punishment is anywhere from 5 to 99 years or life in prison and up to $10,000 fine.
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you are giving up those rights. Did you intend to give up those rights in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Smarto, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, sir.
Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, sir.
According to the plea, punishment is to be assessed at 8 years in the prison. There's a $2,000 fine and no applications. Did you understand that to be the plea?
Yes, sir.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal?
Yes.
The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Then to count 1 in the indictment, how do you plead? Guilty, not guilty, or no contest? State any evidence to support the defendant's plea?
State offers states 1 in attachments.
No objection.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports But most importantly, there'll be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
He's been very honest from the get-go, including in the police report. We'd just like the court to accept his plea agreement.
All right. The court will find you guilty. The court will sentence you to 8 years in the prison. Give you credit for any time served. There's a $2,000 fine, time and money to run concurrently. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing. Fast money, not good money. I bet you end up with fast money and you don't even know where it went. You can't point to anything and say, that's what I bought it with. This is what my grandmother would always tell me. And I do my best to live by that. And she said, you cannot build your happiness off somebody's misery. And there are people who are suffering from drug addictions, and you can't build your happiness off of that. You understand? When you're released from prison, if you have an issue with drugs yourself, if you have an issue with housing or whatever it may be, if I'm still here, you can come by. I will pick up the phone and call someplace to help you, okay? All right, good luck to you.
Thank you.
Thank you.
Have a big excuse.
Yes, everyone, we're taking our recess. We'll be back at 2.
Judge, I'm sorry to bother you.